Every year, Facebook, Google, and other companies we trust receive hundreds of thousands of orders from law enforcement agencies seeking information we put online, your emails and text messages, your calendar items, your pictures and videos. And big tech companies are not allowed to tell you that they're handing over your information. In a Washington Post opinion piece, Microsoft President Brad Smith writes, "Not long ago, if the government wanted to serve a search warrant as part of a criminal investigation, it had to do so in person with notice. An agent or officer needed to bring a signed warrant to a house or building and hand it to the target of the probe at the front door. Only then could the government search the premises for documents, records, and computer files. By serving search warrants on companies such as Apple, Google, and Microsoft to obtain emails and messages that belong to our customers, government prosecutors also ask courts to impose gag orders on companies such as ours that prevent us from letting people know that copies of their emails are now in the government's hands." Creeped out yet? This has been going on for a long time, and the nobly aimed Patriot Act threw gas on the flames. What's wrong with this picture? Let's ask attorney Madeline Pendley from Levin Papantonio Rafferty in Pensacola. Madeline, welcome.
Thanks for having me.
How hard is it to get a search warrant for my home or workplace? And how much easier, if it is it to get a warrant and instead search Apple or Google or Facebook or some other platform I use?
In either situation, they're going to have to show a cause for you to be investigated. But just as you mentioned, it's actually much easier now, at least not terribly difficult, to get a search warrant or a subpoena for intelligence purposes, which usually includes things like data and internet search history. It actually started with the Reagan administration. In 1981, he created an executive order that gave broad surveillance powers to the NSA. It's been amended several times, like you mentioned, most recently in 2008 by the Patriot Act. So since then, it's actually seemingly easier to get a subpoena or warrant for internet or intelligence-based information rather than a warrant to enter somebody's home.
We've all seen enough cop shows on TV to be able to recite the Miranda warning, "You have the right to remain silent." Madeline, can what we post on social media, which is out there in public, or what we have written person to person, more privately in email, be used against us in a court of law?
Unfortunately, yeah, it can. There's two different scenarios there. You've got the public information, your statuses, what you're posting to other people publicly, your photos. All of that can absolutely be used in a court of law. No warrant required, usually. As far as the private messages, it's a little bit more complicated. Unless the person you're communicating with turns that information over to the government is supposed to have a warrant or a subpoena to get that information, unless they ask the judge for permission and they just get to go to the tech company themselves. Either way, yes, all this information is admissible in a court of law.
When surveillance and privacy and matters like this come up, we will often hear about a reasonable expectation of privacy. In 2021, Madeline, what is a reasonable expectation of privacy?
So from a common sense standpoint, I think we all understand, you can be watched at any time, but that's really not the legal expectation of a reasonable expectation of privacy. From a legal standpoint, all you have to have is what a reasonable person, basically be offended by the intrusion. So the classic example is bugging somebody's phone without a warrant. There's a reasonable expectation that only the person on the other end of the phone call is who's hearing the conversation. So actually, the Supreme Court ruled in 2018 that cellular data and information like that is protected under the Fourth Amendment, that people do have a reasonable expectation of privacy when it comes to their cellular data and search history, which makes sense. What is more revealing about a person than what they do on the internet? You can see where they shop, where they traveled, you can see their location, maybe their bank account history, who they talk to, what they think about. So it definitely makes sense that this type of information is protected. But the problem here is that when the government is subpoenaing this type of information, like you mentioned, the target of the investigation is not aware. So they don't have the same ability that they have in an in-person search and seizure to bring up issues to the court to say, I feel this is improper, this should not have happened. They're not aware of the search at all, so they can't invoke those Fourth Amendment protections.
And in terms of the people who are on the phone together, even recording that call, the rules vary from state to state, correct? In some states, both parties must consent. In some state, only one party may consent to recording the call, correct?
Exactly. In Florida, you can't record a conversation without somebody's permission. You can't record anybody at all without their permission. So even, Florida ultimately offers more protections in that regard than some other states. But yes, you're exactly right.
Madeline Pendley, Levin Papantonio Rafferty Law Firm in Pensacola, thank you for stepping into the big picture. Come again, will you? Government isn't the only peeping Tom. There is an entire industry selling information about what you do and who you know. Have you ever been to Amazon.com? Are you on Facebook, Instagram, or LinkedIn? Ever search on Google or Yahoo? This is just a partial list of places that surveillance vendor SocialNet is watching. If you or your friends spend time in any of those or dozens of other cyber neighborhoods, here's what SocialNet subscribers can learn about you.
Start with a name or alias. Search social networks. Search for friends, followers, or following. And even retrieve additional information, like locations, hobbies, or other helpful clues. You can visualize one-to-one correlations, as well as multiple relationships and networks of people into the thousands of records. Through link analysis, SocialNet can uncover key puzzle pieces for investigations of all kinds.
Clients of companies like SocialNet and Caseware and Shadow Dragon and other similar vendors include intelligence agencies, government, police, corporations, even schools. How much are we to blame for our dwindling personal privacy? Here's RT Boom Bust co-host and investigative journalist Ben Swan.
Well, Holland, it really is just a few companies that seem to be leading the charge into this high-tech world for home gadgetry. The only problem is that the more we look at this tech, the more it seems like it's creating a high-tech surveillance state. Amazon is leading the charge on this. Recently, the company showed off an autonomous 20-pound dog-like robot named Astro with large cartoony eyes on its tablet face and a cup holder. This robot, not unlike Alexa on wheels, uses voice recognition, software, cameras, artificial intelligence, mapping technology, and voice and face recognition sensors as it zooms from room to room, capturing live video and learning your habits. What could possibly go wrong? Now, believe it or not, it's not the most invasive thing that Amazon is rolling out. The company, which acquired the Ring doorbell in 2018 for $1 billion, has announced a subscription service where third-party professional monitoring companies will analyze live feeds through your doorbell cam. Amazon also sells a $250 drone called Always Home Cam with an attached camera that can automatically fly around your house and stream video to your smartphone. But it's not just the surveillance inside and around your home. Facebook has now rolled out its Ray-Ban smart glasses that allow a user to record video, take photos, and even answer phone calls. The glasses have a physical switch on the inside to turn off the capture features, while they also allow for a flash of an LED light on the front so that people know they're being recorded or in a photo. The only problem is that a small piece of tape can be used to cover that light, and people in public then wouldn't know they were being recorded. And one of the big legal questions surrounding all of this, Holland, though, is how much access does law enforcement have to these gadgets and the recorded audio and video feeds that they are collecting? For instance, we know that the Ring video doorbell has already been used by law enforcement in order to monitor activity on a certain street or in a certain location. The question is, how much access will law enforcement now have to the video captured inside your home or out in public when someone's wearing those Facebook glasses?
Ben, we ourselves give away a lot on social media. Suggest some do's and don'ts. What can we do and not do to avoid oversharing?
Well, there's a couple of important points there. Number one, you have to recognize that you are the product, right, of all of these companies. So what information do you need to keep private in comparison to the amount of convenience you want to have? So just as a for instance, with the Astro dog that's people might be buying in their home, do you want that to have access to your entire home? How much of your home are you going to give it access to? Do you keep it in only certain rooms? Do you control your conversation and the people that you're talking with when you're in those rooms? How about Alexa, for instance? Alexa cameras, some people have them all over their house, and therefore it's recording every conversation you have. Alexa does have a switch that you can go to and manually turn it off. So at times, do you turn that off? Do you keep it out of your bedroom? I mean, there are certain steps that you have to take in order to recognize that all of this information is being cataloged and it is being recorded. And one other important note on that, when we're talking about this issue of law enforcement, and I know you were talking about it with your previous guest, Holland, you have to remember that law enforcement has a responsibility to go to a court in order to extract information or get a warrant. However, they don't always have to have a warrant if a company willfully gives it up. A company like Amazon loves to work with law enforcement. It's one of their new markets that they want to reach out to. So if Amazon simply hands over your information without a warrant necessary, there's no obligation on the part of law enforcement to get one if a third party is handing it over.
Yeah, the government is a big client of big tech. RT Boombus co-host and investigative journalist Ben Swan, thank you. Skynet is having a feeding frenzy.